in the aggregate, right? What is the line? And I want to emphasize that to you to relook carefully at 6.13. All right, in terms of the A, B, C, and D. Right? So if you cannot complete verification, then that's it. All right. Now, in terms of the next paragraph, 6.14, that's in relation to existing customers. Well, especially they're talking about predate. Any existing customers that predate the coming into force of the notice, then you should prioritize the remediation of higher risk customers. All right. So again, the existing customers predating the notice, the effect of this notice, then you should prioritize the remediation of higher risk customers. Meaning to say, higher risk customers you must do first. All right. Especially when you are looking at any significant transactions since measures were last performed, having regard to the manner in which the account is ordinarily operated, right, in relation to whether there's any material change since the measures were last performed. Here the measures here refer to the customer diligence measures, right? Because before that, there's no stringent requirement for the performance of CDD measures, right? And we'll take a good look at 16.14.2a in relation to customer accounts which predate the operation of this particular notice and guideline. Okay. Now let's quickly look at 6.15, right? And here it talks about screening, all right, which again we have discussed a little bit regarding screening in the notice provisions under FA number 6. Now 6.15.1 states that it is a preventive measure, right? And the financial is reminded that all parties identified pursuant to the notice are required to be screened. Now underline the next phrase there, irrespective of the risk profile of the customer. So screening becomes part of the integral process, right, of identifying the risk profile of the customer. Now 6.15.2 is new, so I will go a bit slow, where screening results in a positive hit against sanction list. Now, I've spoken to you about sanction list earlier, right? So when you do a screen check of a customer and there's a positive hit against the sanction list, right? The financial advisor is reminded of his obligation, note this one, to freeze without delay and without prior notice. You don't tip off the customer. Remember I talked about tipping off? All right, tipping off carries a $30,000 fine, maximum, or a jail term, right? Now, if you do your screen check and there's a positive hit against a sanction list regarding this particular person or customer, right? Then the advisor is reminded to freeze without delay. That means you're going to freeze the account and without informing the client, the customer, prior notice. The funds or other assets of designated persons and entities that he has control over, so as to comply with the applicable laws and regulations in Singapore, including the TSOFA and the MASA regulations issued under Section 27A of the MAS Act, relating to sanctions and freezing of assets or persons. All right, so one must be familiar with this particular law and regulations regarding the freezing of assets or persons. All right. So if any such asset should be reported promptly to the relevant authorities, and the suspicious transaction report should also be filed. Okay, so that's the importance of screening. All right, it's a preventive measure, and it is a positive hit. All right, and therefore you need to freeze the assets of this particular person or customer without prior notice. All right, so one has to look at the particular law and the particular section, right, under the MAS Act and under the TS OFA, the Terrorism Suppression Financing Act. Okay. So that is the new thing that I want to alert you on. Right, and then 6.15.3 sets out what must be put into the policies and procedures and controls to set out A, B, C, D, E, F. All right, in relation to the process of screening. All right? And I want to direct your attention to C, the frequency of review of the policy by the board or the senior management or by the risk management unit, right? And the frequency of periodic screening, right? Monthly, quarterly basis. And how apparent matches from the screening are to be resolved by the employees' representatives, the financial advisors, the employees, including the process of determining that the apparent match is a positive hit and dismissing an apparent match as a false hit. Okay? So there's a lot of technical issues there to identify that person and whether there's a positive hit or a negative hit or a false hit, right? And steps to be taken by the FA employees for reporting positive hits to the financial advisor, senior management, and to the relevant authorities. Okay? So that's regard to the guideline on screening, right? Now, 6.15.4, level of automation used in the screening process should take into account the nature, size, and risk profile of the financial advisor's business, right? So if your business is big, large, right, therefore you need to automate this screening process. All right, so you must take into account the shortcomings, all right, of this automatic system, right? And here it is emphasized to you in this guideline, and I read to you at 6.15.4. In particular, it's important to consider fuzzy matching, all right, to identify non-exact matches. And here it's suggested to you the financial advisor should ensure that the fuzzy matching process is calibrated, right, to the risk profile of his business. Right? As application of the fuzzy matching process is likely to result in the generation of an increased number of apparent matches which have to be checked, the financial advisor's representatives or employees will need to have access to CDD information to enable them to exercise their judgment to identify true hits. All right. Now, this is the internal operations of the financial advisor if you automate the screening process. All right. So, as with any computerized or automatic systems, there are shortcomings. All right. So, therefore, the necessary steps must be taken. Right. To ensure that these shortcomings are addressed properly. Right? Now look at 6.15.5. Now this one I highlight to you as important. A financial advisor should be aware that performance screening after, circle and underline the word after, business relations have been established could lead to a breach of relevant laws and regulations in Singapore relating to sanctioned parties. Now, what does this mean? Right, so this means that your screening must be done before business relations. All right, so if you allow a customer to transact, to trade, right, and you do not do the proper screening until after the business relations has been established, then there is a possibility that there may be a breach of the relevant laws and regulations relating to the sanctioned party. All right? And you don't know that this is a sanctioned party, a sanctioned customer. All right? So when the financial advisor becomes aware of such breaches, he should immediately take the necessary action and inform the relevant authorities. All right? So this is an issue that you need to address if you allow a customer to trade before screening, before proper screening is done. Right? 6.15.6, in screening periodically as required by the paragraph 6.38C of the notice, A financial advisor should pay particular attention to changes in the customer's status. Right? I mentioned this to you a couple of times before, where a customer has over time become subject to prohibitions or sanctions. Right? So a customer can change his status over time. He or she may be a subject to prohibition or sanctions. Or customer risks. Example, a connected party of a customer, a beneficial owner of a customer, or natural person appointed to act on behalf of the customer subsequently becomes a politically exposed person. A point which I alluded to earlier to you, in case of myself becoming a politically exposed person, or presents higher MLTF risks on the customer subsequently becoming a politically exposed person, or presents a higher MLTF risk, and assess whether to subject that particular person or customer to the appropriate MLTF risk mitigation under the notice. Right? And importantly, subject that person to enhanced CDD measures. Okay, so that is the important point I want to drive to your notice, to your attention, that this screening is important. Right? You've got to do it periodically, right? To ensure that there's no change in the status of that customer. Right? Or the person appointed to act for the customer, or the beneficial owner, or a connected party to the customer. Alright, so there are 4 different types of checks you need to do, and there are 4 different types of screening you need to do. Right? Right, I think I've emphasized that point enough, so I just want to draw your attention to 6.15.5 and 6.15.6. Okay. Now the rest are all right. They are all similar. Now, I just want to cover 6.15.8. Right? Now, the financial advisor should ensure there is adequate arrangement to perform screening of the financial advisor's customer database, where there are changes to the list of sanctioned individuals and entities covered by those sections. All right. Now, here the guideline refers to a particular notice, all right, MAS notice. Under Section 27A of the MAS Act, an MA notice, now refer to this one, MANEXT1/212. Prohibition on transaction with the Iranian government with Iranian financial institutions. All right. Now this is Iran, or somebody may pronounce as Iran. It doesn't really matter, Iran or Iran. All right. So in particularly, as I mentioned to you before, MAS does issue notices in relation to sanctioned persons. Right. So here they give an example only here in this case. I mean an example in terms of the Iran or the Iran sanction. I've read some of this over the internet. There are sanctions against Congo, there are sanctions against North Korea and other jurisdictions. All right. So take a look at the sanction list, then you will have a better picture, a better idea what is being written here. Now here it says the financial advisor should implement 4I checks on alerts from sanction reviews before closing an alert. Right, or conduct quality assurance checks on the closure of such alerts on a sample basis. All right. So 4I checks. What does 4I checks mean on these alerts? So 4I checks meaning to say 2 persons, 2 individual persons. Right. What sometimes in law we call it a 2 persons rule. All right, a 2 persons rule. All right. In other words, you need 2 persons, 2 separate checks, right, by 2 different people, right, to make sure that the decision is correct, right? That's the meaning of 4I checks. Now, very quickly, paragraph 7, then simplify customer due diligence. We have done that already in the notice provision, so I'm going to skip that, except to ask you to look at 7.3. All right. May adopt a risk-based approach in assessing whether measures should be performed for connected parties. All right, so this in terms of the the SDD, the Simplified Customer Due Diligence. All right, and essentially, when can you do the Simplified Customer Due Diligence? Well, the answer is a simple one. So when you make the assessment or the analysis that the risks are low, right? So when the risks are low, then, well, you can do your Simplified Customer Due Diligence. But having said that, one has to be careful in this regard, right? And 7.5 there on that page says that subject to the requirement that a financial advisor assessments of low risk supported by adequate analysis of risk. Examples of potentially low or lower MLTF risk situations include, then they give you a list there. Customer risk is low if you look at a Singapore government entity, all right, a government department or a state board or an agency of a government. All right, so the ML and TF risk may be relatively low. Then A2 talk about entities on the stock exchange in Singapore or subject to regulatory disclosure requirements is in another jurisdiction. And then 3, FI Incorporated established outside Singapore. They're subject and supervised for compliance with AML, CFT requirements, consistent, underline that, with the standards set by FATF. So that is also considered a lower level risk if the jurisdiction complies with the standards set by FATF. Right? Then you have the product, service, transaction, and delivery channel risk, which we have talked about. Then very quickly coming down the page, paragraph 8, we talk about enhanced customer due diligence. Right? Okay, so examples of potentially higher risk categories under paragraph 8.7 of the FA number 6 notice, giving you example again below. Customer risk, right? A1, 2, 3. A1, 2, 3. Across the page there, 4, 5, and 6, right? Right, look at 6, we have cash intensive businesses, right? So that may be potentially higher risk if the customer deals with cash all the time. All right, working backwards, you look at paragraph 5 there, companies having nominee shareholders or shares in bearer forms. Right, so these are higher risk customers. Business relations is conducted under unusual circumstances. Right, example, significant unexplained geographical distances between the financial advisor and the customer. Right, 3, legal persons or legal arrangements, they are personal asset holding vehicles. Ownership is very complex, complicated, a lot of layering. All right, and customers from higher risk business. Right, higher risk business meaning we are talking about, for example, maybe production of weapons, production of guns and stuff like that. Right, higher risk business. Right, so yeah. Okay, so we have done all that. Then again, look at paragraph 8.4. These are definitions of PEP. Now we have done PEP in the notice provision earlier. Here again, they give you a lot of detailed guidelines as to how do you determine whether a person is a PEP or not. All right. Now very quickly, you look at 8.4.1. All right, second line there. The notice under the definition of PEP is not intended to cover middle ranking or more junior individuals in the categories. All right, so underline the word "not" there. So you are middle level ranking person, a junior person in the categories listed in the definition, then you are not classified or considered as a PEP. Now 8.4.2 in the context of Singapore, your domestic PEP, as I've told you earlier in the notice, government ministers, members of parliament, etc. Now, then the definition of close associate. I've mentioned to you before, it's very difficult to define what is a close associate. All right, I mentioned to you probably can be a golf kaki or a mahjong kaki or even a driver. All right, here the guideline tries to give you more meat, as it were, more content, more substance, as it were, in relation to what is the meaning of a close associate. So here it says the financial advisor may consider factors such as the level of influence the PEP has on such a person, or extent of his exposure to the PEP. Right? Extent of his exposure to the PEP. Right? So if you look at the driver of a PEP, the extent of his exposure, so can you consider a driver as an associate? Well, that is a question mark, right? The financial advisor may rely on information available from public sources and information obtained through the customer interaction, right? So if a customer is seen to be with this PEP for a long time in public, all right, or other available information, then do you consider that person as a close associate? In which case, you have to do enhanced customer due diligence. Now, as I said, this is really a judgment call, all right, in terms of whether you classify, whether financial advisor classifies a person as a close associate of a PEP. Now, more guidelines are given to you in relation to paragraph 8.1 of the notice in terms of international organization, which I have explained a little bit earlier when I was talking about the notice provisions. And here it gives you examples, United Nations, which I think I've mentioned, all right, and affiliated agencies such as the International Maritime Organization, International Monetary Fund, I think I mentioned this, regional international organizations such as the Asian Development Bank, I think I mentioned this as well, the ADB, then Association of Southeast Asian Nation Secretariat, institutions of the European Union, and so on, all right? So all the list is there, and this listing gives you just some examples or illustrations. All right, the meaning of an international organization. All right, so that's that. So when you have a person at a high level working in these international organizations, then that person may be considered as a PEP, and again, in which case, enhanced due diligence will have to be conducted, right? Conducted, right?